Welcome back.
My first concern,
Yes, that was Eric Williams. This is Alfred Lambermont Weber on Exopolitics Radio, and we're very privileged today to have with us as a guest Eric Williams, who is an advocate for sovereignty, personal freedom, and the grand jury. Welcome, Eric.
thank you very much, Alfred.
Well,
My first concern, go ahead.
yes, you were saying that your first concern is.
My first concern is why does everyone in the freedom movement insist on making the insertion of political sovereignty so complicated when it's really very simple? Back in 1970, I was prosecuted by the IRS in federal court in Los Angeles for criminal willful failure to file or pay income tax. At the trial, at the very outset, I challenged the IRS prosecutor to present evidence that I was among those he claimed had various citizenship obligations. When my case was called, there were only 5 people present in the courtroom: the judge, the bailiff, the clerk, the prosecutor, and me. The prosecutor began his opening statement saying, citizens of the United States have an obligation to do things that he started listing off. I said, I object. The judge said, why are you objecting, Mr. Williams? He hasn't said anything yet. And I said, well, he said citizens of the United States have an obligation to do all those things he was listing, and that may be true, but he doesn't have anything in his file to put me in that class. The judge then asked me if I was renouncing my citizenship, and I said, how can I renounce that which I never applied for? The judge then asked me where I was born, and I said, at the time that I was born, I just gone through a terrible ordeal. I was gasping for breath. I could neither read or write. I didn't know who I was, where I was, or even what I was. The judge then asked me what my mother had told me. And I said, at the time that I was born, I did not then understand the relationship. I got my mother out of a lineup. The judge then asked me where and I said, the judge then asked me what was on my birth certificate. And I said, at the time that I was born, I did not understand the importance of such a document. I don't know if such a document was created regarding my birth or not. And I denied that any was. And pointing at the prosecutor, I said, he can't prove it. When neither the court, judge, or the prosecutor could establish that I had volunteered myself into being a U.S. citizen, no matter that to the best of my knowledge, I was born in California. Being born in the United States, by the way, does not cause such individual to be designated as a citizen due to such a birth. Because the IRS could not establish that I had voluntarily submitted myself to the jurisdiction of the IRS or federal or state government, the judge then said he was taking the matter under consideration and that I would be notified. That was 44 years ago. I'm still waiting. Some people assume that because my event was 44 years ago, that challenging the political jurisdiction would not now work. During the past year, there have been several people who have presented letters to the IRS challenging the ability of the IRS to present evidence that they had volunteered themselves into subservience to the IRS or federal or state governments. I am not aware that any of such letters have failed to ward off the IRS or state tax collectors. Some of these individuals are still using their driver license and social security numbers under the law of necessity recognized by the Supreme Court in a case called Holy Trinity Church versus United States. I think that was in 1892, where the Supreme Court wrote that when the strict application of the letter of the law or constitutional provision would result in an absurd outcome, the law or constitutional provision must be applied and a manner to avoid the absurd outcome. My challenge was and is based on the 13th and 14th Amendments, which have not changed since 1970. Because so much of what was in the 1960s did not work. And I got involved in this freedom movement in 1964 when Barry Goldwater was running against Lyndon Johnson for president of the United States. I campaigned for Barry Goldwater. And because of that, I got involved in the freedom movement. And when what they were then advocating did not work, I went back to the beginning of this country, back to July 4th, 1776. Prior to that date, everyone here in the then 13 colonies was under the dominion of King George III of England. However, on that date, when King George was kicked out, at that moment, there was absolutely no government here in what a moment prior had been under King George. At that moment, on that day, everyone present became politically equal. There were no more aristocrats, and there were no more commoners. Everyone became individually sovereign over their own person with no authority to command the subservience of any other person. It helps if we mathematically think of each persons of others as being equal. When each person's authority over others is equal to zero, how many zeros would be required to be added with a total greater than zero? This establishes with a mathematical certainty that although the Founding Fathers could certainly get together and create any manner of organization that they agreed upon, but there was zero possibility that the founders could have any authority or ability to imbue their creation with any authority to command the subservience of any individual who did not individually volunteer to submit his or herself to the government created under their Constitution. 0 plus 0 would still equal 0, and in 1866, the ratification of the 13th Amendment instilled the acknowledgement of this mathematical certainty into our Constitution. This information is not all complicated. It's very simple. It does not require any significant study or research for anyone to be able to understand. It doesn't require anyone file any rescission documents with any government agency. All we need to do is examine how our government manages our society to entice us individually to volunteer ourselves into subservience to its rules. It is very important for those who have been confused by all of the conflicting information prevalent among the freedom movement to understand how vulnerable the human child is to indoctrination, and that this vulnerability does not significantly diminish as we grow older. Thinking is very hard work. Now, none of us like to do any more work than is necessary. So when others tell us what we want to hear, and when they tell us they have a solution in regard to how we got under control of the government because our names are written in all capital letters or because of gold fringe on the flag, and that the government has taken over ownership of us through the bundling and sale of our birth certificates, and that our Republican form of government has been turned into a corporation, we presume that those who tell us these things have done their homework. But they have not. As I have revealed here in what I said earlier about how 0 plus 0 will always equal 0. When the mathematical certain fact is applied to all the information, the effect of all these assertions just vanishes because none of it overcomes 0 plus 0 equaling 0. As this is irrefutably true, it is not possible for any of the reasons prevalent among the freedom community to be true, and so complicated. Let's keep it simple. So how were we enticed to volunteer ourselves into political servitude? The Constitution was written by aristocratic men who were politicians who had been in charge of the commoners under the British monarch for literally centuries. For all of them to willingly give up their aristocratic position to agree to be politically equal to scrub women and stablemen without a whimper is just too much to believe. It is amazing to me that very few of the members of the freedom movement have any qualms about the true intent of the founders. They were politicians. This means they were accomplished in manipulating others. This means that they knew very well how to write legislation or constitution so that there would be loopholes for themselves and their friends to work around whatever they were imposing on the commoners. And it also means that they knew how to write a constitution where there would be no such loopholes. So why did they give us this sieve? For whose benefit were all those loopholes provided? Flip that and consider, who was it that was intended to be enslaved under the Constitution? Just take a look around. Try your mirror, the one that magnifies. An argument can be made to establish that everything that has been done and is being done is supported by the Constitution. Everyone reads the comments and admonishments of the founders, written or presented by them outside the Constitution, as to how important it is to keep a watchful eye on the government to keep it on track with the Constitution. But why did they write the Constitution? Why didn't they write the Constitution to more securely prevent the problems they perceived as arising if the populace was not unrealistically vigilant? Is it reasonable that we should have to continue to watch everything that politicians do in order to keep them in conformance to the Constitution? And when the rules set down in the Constitution are written in a way that the politicians can reasonably support everything that they are doing as being constitutional, how do we prevent them from instituting the micromanagement of us that they have? The commoners of that time wanted and expected a society where there would be one political class. A republic is not such an organization. Nowhere in the history of man is there one single society that has been governed by the commoners, or where there was only one political class. Why were those present back then, and why are the freedom advocates of today so adamant in their concern and demand in regard to having and restoring a republican form of government back then and here in our time? Or, wait a minute, was there any such advocacy or demand on the part of the commoners back then? I don't recall ever hearing about any such issue by the commoners. So why did the aristocratic framers of the Constitution include that provision guaranteeing a republican form of government to the new states? And why do the filings of the New York grand jury put such adamant insistence that this constitutional provision, which they seem to believe and claim has been in some way eradicated, be restored? Where in the federal Constitution is there any overt evidence declaring that this document created a republic? What is a republic? According to the content of their filing and the footnotes included therein, a republic is a form of society where the people are in charge. In charge of what or who? One of the footnotes included by the New York grand jury in their filings, taken from the New York state codes, provides that the people are over the citizens. Does not that footnote indicate that there are two political classes here in the United States? The people being the ruling class and the citizens being those ruled? In regard to the word citizen and people, this is really important to understand. A lot of people miss this. Some words have an inherent political meaning and some do not. Most do not. But those words which do not can be imbued with a political meaning if the context in which they are set is a political context. And while we are considering this, it is also advisable to be aware of the propensity of politicians to use certain words as what is known as terms of art, which means with devious, unrevealed intent. It is self-evident that the word citizen is a political word which constitutes an acknowledgement of subservience to a political superior, no matter the context, such as this. all the citizens in the swimming pool or all the citizens watching the football game. Is there any doubt that both references to citizens indicate a subservience to a political superior? So if the word people were substituted, would there be any such political subservient implication? All the people in the swimming pool or all the people watching the football game? Is there any political implication there? Certainly not. If we carefully read the preamble to the Constitution, paying attention to this political context in which the word people is set, we have in relevant part, quote, "We the people of the United States, in order to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Is it not self-evident in this political context that the word people is automatically imbued with a political meaning, and that it is now a political term of art whenever it is used in a political setting, especially in the Constitution or in the Bill of Rights, wherein these devious politicians can use it to subjugate innocent common people, as they did in their condensing and rewording of the 50 amendments to the Constitution that were proposed by the commoners of the 13 states, where the commoners used, the aristocrats, when they condensed those 50, they used the word people in the 5 most critical of those amendments and totally avoid using the word citizen, because if they had used both of those political status words in the Bill of Rights, the commoners would have seen the scam and would have objected. They would have then been informed that there were 2 political classes, which is what they had revolted against with King George. The purpose of the preamble is very important, but is usually overlooked. The preamble establishes the purpose of the Constitution and declares the source of its authority, which is clearly stated to be the people of the United States, to secure the blessings of liberty to them and their posterity, excluding any reference to citizens or their posterity. In order to have the authority to declare such purposes, those doing so must be politically sovereign. Those doing so must be subservient to no political superior, man, or entity. At that time, was there anyone or any entity present in North America who had more political authority than the people of the United States? Clearly, there was no such superior political authority. In the preamble, the Founding Fathers established that the people of the United States were sovereign. This meant that neither the people nor their posterity would be subject to comply with what they established in the Constitution. This indicates the purpose of the Constitution was to govern the government, to prevent it from treating the commoners as a politically subservient class. However, a careful study of the Constitution with a suspicious eye will reveal that the Founding Fathers had a different intention. The establishment in the preamble of the sovereign status of the people was open and notoriously done. Everyone then present knew they were of the people of the United States, so no problem was perceived, except by Patrick Henry. When Patrick Henry read the Constitution, he said he smelled a rat and he would have no more to do with it. Unfortunately, Patrick Henry did not discern where the rat was that he smelled. Now is where the Founding Fathers get tricky and devious. These politicians creating this political document are going to ambiguously and surreptitiously create a subservient political class citizen of the United States. This is done in Section 2 of Article 1, where it's made clear that U.S. citizenship is not acquired by birth, because it provides that to serve in the House, the citizen must be 25 years old and 7 years a citizen, and to serve in the Senate 30 years old and 9 years a citizen. Please take note here that there are no limiting eligibility requirements established for those of the ruling people class to serve in any of the offices of the federal government. So there now the founders created their subservient commoner class, causing the political entity of the United States of America to be a republic. Do these provisions give us cause to have some concern about the actual parental intentions of the founding fathers? Am I the only one who perceives a concern in regard to the word republic being used here in the Constitution and in the filings of the New York? Because I see the word republic and the official name of 100 totalitarian dictatorships on this planet, such as the People's Republic of China and the Democratic People's Republic of North Korea. I have written about this in other comments on Gene's blog as to why the founders included this constitutional guarantee of a Republican form of government in all the states, being so that all of those of the former aristocrat class could move to an outlying territory and create a dukedom for themselves where they could have control over their subjects, except there we would call them states and governors rather than dukedoms and dukes, and citizens rather than subjects. What is the significant difference? In regard to the filings of the New York Common Law Grand Jury, I contend that their use of the word common law is one of the reasons why their papers have been rejected by the New York state courts. Who was it that included in these rejected filings all of the exceedingly strong emphasis on common law and in regard to that the Constitution guarantees that every state have a Republican form of government to do with the reestablishment of the people's control, the grand amendment, where the grand juries don't mention common law. And every time we mention, or the term common law is attached to the, I think that we're a big mistake shooting ourselves in the foot because it strongly implies to the existing system that our intention is to eliminate the current system. And of course, we can't do that. We have no intention of doing that. Everything that is established is under the Constitution. And the Supreme Court has acknowledged that there are 4 different levels of government. 3 of them are established in the Constitution. That is the executive, the legislative, and the judicial. But the 4th, the grand jury, is not in the Constitution. And the Supreme Court has acknowledged that because of that, none of those 3 primary bodies of the federal government have any authority to regulate the grand jury. The grand jury is totally independent, but it must still respect the Constitution and the 3 other branches of government. So whenever we go around using the word common law, implying that we are going to displace the other 3 branches of government, we're making a very serious mistake. And I think that that is part of the reason why the courts of New York have refused to consider the filings of the New York grand jury. All of this ranting to restore the republic has caused great confusion here among the common people, especially in the very divergent opinions.
Hello?
I don't know what's going on.
Hello?
Hello, Alfred. Are you there?
Yes, I am.
Okay, my computer just put cleared the screen, so I don't know what happened to my Skype.
Yeah. No. Keep.
Okay.
We were cut off, but keep on going.
Okay. Okay. There you are. You came back.
Yeah.
Okay, what we need to do here then, is go to how an individual in the United States becomes subservient to the government.
Okay.
Citizenship is not established. Citizenship is not established in the Constitution, in the 14th Amendment. Everybody has been indoctrinated to believe that it's in there, but if you really take the time to read that first part of the 14th Amendment, there's nothing in the 14th Amendment that declares those persons born in the United States become a citizen of the United States due to their birth here in the United States. The wording is, all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. It's very important to pay attention to that explanatory clause between those two commas, and subject to the jurisdiction thereof. The first part before that says all persons born in the United States. If they do something to become subject to the jurisdiction of the United States, then after they do that, then they will be citizens of the United States. The wording of the 14th Amendment is not as follows. All persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. We have that explanatory clause in between there, meaning that you must, in order for you to become a citizen, you must have done something on a voluntary basis in order for you to become a citizen. The 13th Amendment prohibits involuntary servitude. Neither slavery nor involuntary servitude shall exist in the United States. That prohibits citizenship by birth. That prohibits any government entity from declaring anyone born here is subservient to any level of government. When we are born here, we are politically sovereign and politically independent. That's what our status is when we are babies. When we are born, we do not decide what our name is going to be. Most of the time, I expect it's our parents that come up with our name, not us. We're just babies. We were just born. We don't even know that we were born. We don't even know that we're humans. We don't even know if we're a boy or a girl. We don't even know if there's a gender difference. We don't know anything when we're born, and we have no ability to participate in the creation of our name or of the entry of that name on our birth certificate. What that indicates is that name is not ours, and that birth certificate is not ours. They belong to someone else. Because our parents came up with a name, they could claim ownership of the name on the birth certificate. But guess what? The birth certificate is designed by the state, and the state doesn't want the parents to be alerted to the fact that names can be very valuable property. Is the name McDonald's a valuable name? Of course it is. And so are many, many other names very, very valuable. And every adult's name has value because they have a job and they have income and they pay taxes. And that gives them value to the government. So the government wants to be able to, using some means, become in control of everyone so the government can require everyone to pay taxes. So the way the government does that is by designing a birth certificate where there's no information on that document to suggest to the parents that the parents could claim an ownership of that name. So the parents don't do that. They just put the name on the birth certificate, or they give it to the hospital staff, and the hospital staff puts it on. However, doesn't make any difference. The birth certificate is then recorded with the government, And then every state has a statute for the state's disposition of abandoned property. In Arkansas, it's under Title 18, 28-202. Section 202 is a catch-all clause that pertains to all property that's abandoned that is not specifically mentioned in the previous sections, which would include the name on the birth certificate. So, and that Section 202 provides that 5 years after the last contact of the original known or unknown owner, that unspecified property will become owned by the state of Arkansas. Now, other people have informed me, living in different states, that the years may vary from the ones that have told me from 3 to 7 years. In Arkansas, it's 5 years, whatever. By the time we become 16 years old, the state has become the owner of that name on that birth certificate. It's not our property, and our parents cannot legally give it to us because they abandoned any ownership claim when they failed to enter an ownership claim on the birth certificate. So the state has become the owner of the name. Now, it's important to understand that there is nothing on any birth certificate that can connect that birth certificate to any particular individual. A young 16-year-old man could use any of thousands of different birth certificates as long as they had the correct race and the correct gender and appeared to be about presenting the correct year of birth, 16 years before that. The clerks in the driver license issuing offices in all of the 50 states, none of them ever asked a 16-year-old driver license applicant if that applicant can prove that that birth certificate was created at the time of the birth of that applicant, because there are no applicants that could ever present such proof, because nobody knows when they were born. Nobody knows when or where they were born or who their own mother is. It's impossible for a human baby to take notice of those facts at the time that they were born. Now, please understand, I'm not saying that the information that the woman who said she was your mother is wrong. I'm not saying that at all. I'm saying you, as an individual, cannot have personal recollection of it. You only have secondhand information told to you by a woman who said she was your mother. She probably was. I'm not saying she wasn't. That's not the point. The point is here, we're dealing with the government, and when we're dealing with the government, we are required to tell the truth. So the truth is, you don't know when you were born. So tell the truth to the driver license issuing clerk. I did this, and they refused to issue me a driver license. Guess what? I wasn't surprised. But I didn't refuse. The state refused. When I'm stopped by a police officer for some violation, and the police officer asked me for my driver license, I say, I'm sorry, officer, I don't have one because the state refuses to issue me one because I don't know when I was born. And the police officer says, you don't know when you were born? Well, everybody knows when you were born. And I say, officer, are you telling me that when you were born, that you were able to look over at the wall at the clock and the calendar, and you know what a clock was, and you knew what a calendar was, and you took notice of the time and the date, and they held you up so you could see your mother's face, so you could recognize your mother when you were born? And they said, well, no, of course not. But, my mother told me. I said, yes, officer, I understand that, absolutely. But the thing is, I'm required to tell the truth to the state. And when I insist on telling the truth that I don't know when I was born, and therefore I don't know if a certain birth certificate had anything to do with me or not, I insist on telling the truth. Why does the state require me to lie in order to be issued a driver license? Well, what I have been able to figure out, officer, is that the state doesn't have any authority to require me to apply for a driver license until I enter myself into a subservient relationship to the state by applying for a franchise to use that state-owned name. So when a 16-year-old goes into the driver license issuing office and voluntarily hands over that birth certificate, the applicant is voluntarily entering into a subservient relationship to the state. And the state is very happy to get another taxpayer, so the state does not question the ability of the applicant to to prove that that birth certificate had anything to do with their birth, and the driver license office clerk accepts the birth certificate, takes the information off of the birth certificate, punches it into the state's computer. The state computer checks the birth records of the state, and if you're born in some other state, all the states cooperate with this information. So the office where you are applying for your driver license is able to check with whatever birth record is appropriate to determine that that birth certificate was filed somewhere, and that therefore the state can issue you a franchise for you to use that name as your true legal name. So every time after that, when you engage in any activity using that state-owned name, you must comply with the rules for your use of that state-owned name. It isn't any different than a McDonald's franchise. When someone wants to open up a hamburger stand and they want to do it with the Golden Arches in order to get the benefit of the McDonald's name, and they apply to the McDonald's Corporation for a franchise, the McDonald's Corporation will grant them the franchise under the conditions, certain conditions, that they pay a percentage of their profit to the McDonald's Corporation, and that they purchase all their supplies from the McDonald's suppliers, and everybody is happy. And the difference there, though, is that everything there is open and above board. The applicant to the McDonald's Corporation knows what they're doing. They know what the contract agreement is, and so there's no dishonesty there. But when a 16-year-old goes to the driver license issuing office and presents that birth certificate, that 16-year-old doesn't have any knowledge or any information to inform that 16-year-old that he is or she is applying for a franchise to use a name that's owned by the state. Therefore, the contract that is then entered into, well, let me go a little bit further with that. And what that constitutes is a contract between the 16-year-old and the state, whereby the young applicant has agreed to submit him or herself to the political dominion of the state. Therefore, they have inadvertently and unknowingly given up the political sovereignty that they were born with. Now, because that was done fraudulently, without full disclosure on the part of the state, if that driver license applicant becomes aware of that and says, hey, wait a minute, if I'd have been told the truth about this, I never would have done that. According to their rules, fraud vitiates all contracts. All obligation on the part of the driver license applicant are gone, void. Not voidable, but void, because the contract was entered into without any disclosure whatsoever. However, at the same time, and this is supported by the United States Supreme Court ruling, as I mentioned earlier, in the Holy Trinity Church versus United States, where the dishonesty and indoctrination of the government, by the government of everyone in this society to believe that they must apply for a driver license and a social security number, and this has become so prevalent in our society that it's virtually impossible for anyone to get a job or to open a bank account or to get insurance on their car without presenting a driver license to the insurance company, and it's impossible to get registration for license plates on your car And if you drive down the road without a license plate, you're just asking every police officer to pull you over. So as a practical matter, in order to have a reasonable life here, you need to have license plates on your car, and the license plates registration officers of the states will not give you plates or an annual tag if you don't present proof of insurance to the state license office. So because of all of that manipulation of the society by the government, we are allowed to use that word. We are permitted, allowed, we are authorized to use the driver license and the social security number in order for us to enjoy a reasonable life here in this society. So therefore, the state no longer is able to command us to do anything. Now, I have several people that I have counseled on this who have written letters to the IRS challenging the IRS to present proof that they knowingly, willingly, intentionally, voluntarily submitted themselves to the government of the United States in order to make them obligated to pay income tax, and none of them have ever heard anything back from the IRS, and they're still using their driver license and social security number. Same thing works in traffic court. When you go into traffic court, and I have received traffic citations for maybe half a dozen times in Arkansas for driving without a driver license. According to the Arkansas codes, when an Arkansas state trooper pulls you over and you don't have a driver license, he is not permitted to allow you to drive away in that car. He must impound the car and he take you to jail. That's the. It has never, ever happened to me, not once. When I explain in a very courteous and friendly manner to the police officer why I don't have a driver license, and they know that what I'm telling them is absolutely valid because they know what the rules are here, and they're the same, I presume, in every state, that in order to be issued a driver license, you have to present a birth certificate, and when you don't have a birth certificate, or you insist on telling the truth, how can I do anything else? I have to go to the store, I have to eat, I have to go to work, I have to do various different things, and I can't really do that realistically in this country without traveling on the roads, and so, I do my best, but what am I supposed to do? I have not refused to apply for a driver license. The state has refused to make a way for me to have one. This brings in the United States Supreme Court case, Holy Trinity Church versus the United States, where the Supreme Court wrote that when the strict application of a statute or a constitutional provision will result in an absurd outcome, the statute or constitutional provision must be construed in a manner to avoid the absurd outcome. Therefore, I can drive without a driver license, and there's nothing the state can do about it because I have done nothing wrong. When is the state going to enact legislation to allow the state license issuing office to issue me a driver license without the presentation of a birth certificate? The thing is, the state can't do that because the state doesn't have standing. Standing is critically important. Before the state can require you to do something, you have to first submit yourself to the state. Until you do that, the state cannot present you with a driver license, even if you wanted one. The same thing applies here, with the grand jury. The grand jury, under the Fifth Amendment, would have the authority to review every statute that is enacted by a legislature to make sure that the statute was reasonable and just, not merely in conformance to some legislation enacted by the legislature. In California, where I used to live, the local city council enacted a statute, or city ordinance I should more properly say, establishing that if someone did not clean up graffiti off of the side of their house or their garage door within 24 hours, they were guilty of a misdemeanor. Can you imagine that? They criminalized the victim. When they enacted that statute, I had my furniture manufacturing company operating in that town, in that city. I went to the local tool rental yard, which was owned and operated by the mayor of that city. And I told him, I am no longer having my crew go out and paint over all the graffiti that they're putting on the walls around my business, because you people instituted that silly statute. I can't wait to be charged with violation of that city ordinance. I always wanted to own a city that might as well be this one. I never was ever bothered by the city authorities for all that graffiti. But to see, the point is there, a common law grand jury could look at that statute and say, this is nothing but hogwash, this is void on its face and of no effect. This is the purpose of the grand jury, to be the people's regulator of the government, to make sure that the government doesn't do things like pass laws that say people cannot collect rainwater off of their roof. People cannot grow food in their backyard, as is being done in some of the communities of this country. Where in the world does the government get any authority to declare that people cannot collect rainwater off of their roof or grow food in their backyard? That's absolutely ridiculous. So a grand jury would be able to review those kinds of statutes and say, no way, those statutes are void. And the grand jury can also, at the same time, do investigations of criminal activity that is brought to their attention, and they can come to a decision as to whether or not a crime has been convicted by, or committed, I meant to say, by some government officer, and they can file criminal charges and bring them to trial. This is right alongside of the civil courts. It might be a judge of the local government court that the grand jury perceives as acting criminally, taking bribes or something like that. Somebody has to be from the people in order to keep the government in line, and that was the purpose of the establishment of the grand jury in the Fifth Amendment. And when the grand jury of New York files all those documents that they have been filing, and they fail in those documents to present declarations establishing that all of the people of New York who are purporting to have to be populating the grand juries of New York, when those jurors fail to provide the state courts with any manner of declaration to inform the court that that the members of the grand jury do have the proper standing to populate those grand juries, the courts don't really have any option but to refuse to consider the documents. This is an example. If there was someone who was making all kinds of obnoxious noise night after night, all during the night, disturbing all the neighbors, and one of the neighbors who was being disturbed by this obnoxious noise called up a friend 100 miles away and told the friend about this 100 miles away, and the friend 100 miles away filed a civil lawsuit against the person who was causing all the noise, and then went to court, the judge would look at the plaintiff and say, "You live 100 miles away from where the noise is?" "Yes, I do." "I'm sorry, but you do not have standing to file this complaint because you are not an injured party. In order for me to look at these charges, you would have to be an injured party. It doesn't make any difference because I have read them unofficially, but officially I cannot consider them because you have stated here that you live 100 miles away. So I can't consider this as a judge." Go tell your friend who lives next door that he's the one who has to file the complaint. Then I can listen, but I can't listen to you because you don't have standing. And that's reasonable, right? So we have the same.
Yes, yes, Eric.
Yes?
Yeah. Let me just let me intervene here, and I realize that you're building several complex points, but there's also sort of a side point coming in, because part of this is a general exposition of sovereignty and grand juries, and then there's something about a New York grand jury, which I myself am not familiar with. But let me go back to the text of the Fifth Amendment, which says, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." Now, I'm trying to understand here where your concept of a sovereign person and the concept of a grand jury intersect. Because it seems to me here that isn't the Fifth Amendment isn't that by creating a grand jury, they're creating a government entity, or are they creating a common law entity? Could you explain that more in your view?
Okay, the grand jury, the Fifth Amendment was not, the provisions, the content of the Fifth Amendment was not included in the Constitution.
Correct.
The Founding Fathers left all of that out. Now, so the reason that it's there is because the people of the United States, as they established themselves in the preamble, they presented their demands to the Founding Fathers to add these provisions. Now, in order to understand who it was that caused this provision, it's important to understand who the people of the United States are and what is the purpose of the grand jury, as has been recognized by the Supreme Court in several cases that they have made comments on. That the grand jury is not subservient to any of the three levels of government that are created in the Constitution. The grand jury is not created under the legislative branch or under the judicial branch or under the executive branch, so therefore the grand jury is outside of them. The grand jury is a fourth branch of government. Now, that's not my opinion. That is a determination of the Supreme Court. So, because the grand jury is outside of those three and it is on their own, it must be populated by individuals who are sovereign. Now, understanding here that it was the intention and belief of all of those commoners, I use the word commoners there, to separate or to make it clear that I am not referring to the aristocrats who wrote the Constitution, but everyone who was there was politically equal. The men who wrote the Constitution, known as the Founding Fathers, they did not have any more political authority than those who previously were under King George were referred to as commoners. When they were commoners under King George, they didn't have any authority in the government at all. But when King George was kicked out, then they were able to exercise their own individual sovereignty to participate in the creation of the government. So under the Fifth Amendment and the grand jury provision there, because as you read there in the Fifth Amendment, the purpose of the grand jury is to bring indictments for high crimes or whatever, no matter who might bring the information to the grand jury, it's the purpose of it being brought to the grand jury is because the grand jury is not under the control of the prosecutor or under the control of the court. So the grand jury is going to look at charges and say, do these activities that this person is accused of, do they constitute a crime? Does the government have any authority to make this a crime? For example, here about 5 years ago where I live, the county government was considering an ordinance to forbid the importation into the county of used mobile homes, because they determined that used mobile homes were not as pretty as new ones and that they would cause the devaluation of property. So the people in the community, who live here in this county, they went to the meeting that night, and there were actually 300 or 400 people there surrounding the courthouse, and the county government backed off because the county government did not have any authority to tell the people of the county that they could not purchase a used mobile home. Now, this would be the kind of consideration that the grand jury would do. They would look at an ordinance like, and they say, wait, the county government doesn't have authority to tell them that they can't buy a used mobile home, or to tell somebody, in my previous example, that if they don't paint over graffiti on their garage within 48 hours that they committed a crime. This is nonsense, and the grand jury would refuse to indict anyone who was charged under that manner of law. Now, if somebody was charged with, a murder, and clearly there was evidence to indicate, somebody is dead and somebody killed him, and it appears as though this is the individual who did the killing, then the grand jury would bring an indictment for that individual to be brought to trial. But the grand jury would not conduct the trial itself because it would not be proper, because the grand jury would have been the investigative body that examined the facts of the case, so it could not possibly be declared to be unbiased. It would be biased, so therefore it would not be reasonable for the grand jury, for any of the members of the grand jury, to sit on the petit jury that would conduct the trial.
Right.
So the purpose of the grand...
Yeah, but now, as a practical matter, isn't it true that the original intent of the grand jury has been subverted by the state, by the prosecutor, by the Department of Justice, or by the state prosecutor that has taken over the grand jury? For example, while all states in the U.S. currently have provisions for grand juries, only half of the states actually employ them, so that they've disappeared in half of the states. And in the other half, it's the prosecutors they are the creatures of the state that use them, so that the common law grand jury is a fiction. Isn't that the case?
Well, under the Constitution, there never was a common law grand jury. It's unfortunate that the individuals in the country that are concerned about how the government is going wrong have, applied that term, common law, because it causes a great concern on the part of the judicial system, because under the common law, there are no statutory laws. Every manner of criminal activity would be judged on the individual merits. If someone believed, under the common law, if someone believed that they had been wronged, they would go complain to the sheriff. The sheriff would take the complaint to the grand jury. The grand jury would consider the evidence, and if they agreed that what the activity that was complained of was indeed a wrongful act, was some manner of crime without any statutory determination. Just wait a minute, whatever they did was wrong. We just don't put up with this kind of activity. It was actually criminal, and whoever did it should not have done it. So we don't know, though, what all the circumstances were. Maybe what was done was justified for some reason we're not aware of. So the only grand jury is to consider the evidence as to whether or not it appeared that there was a kind of wrongful criminal activity, and if so, then appoint a petit jury to do an evaluation of all of the evidence from all witnesses, from all parties, and so therefore, then they would determine whether or not it was a crime without any manner of statute.
Right.
So that's not the case, though, under the Fifth Amendment, because the Fifth Amendment does not provide for a common law grand jury. A common law grand jury would displace the legislative department and the judicial department. Both of those would be displaced.
Yeah.
And obviously, that was not done in the Constitution, because when the grand jury was there to suggest in any way, shape, or form that the Congress or the court system would be done away with.
Right.
But that's what would happen under common law. So we need to stop using that term common law. And you're absolutely right in what you said there, that the grand jury that is established in the Fifth Amendment has been subverted by the prosecutor, by the judicial system, because, well, let me give you this example. During the Civil War, when slaves were escaping from the South and running to the North, the Congress enacted a statute making it a crime for white people in the North to give refuge to these slaves who had escaped. So some of these people were discovered and charged with violating this statute because they were harboring these slaves, and these white people were brought to trial. The jury refused to convict, said because these white people did not commit a crime when they were harboring the escaped slaves. They said they did a good thing. They gave the slaves a place of refuge, so we're not going to convict. Well, when that happened, and other things likewise, the judicial system and the prosecutors don't like that. They want to prosecute whoever they want to prosecute based on their laws and their rules, and they don't care about what the general population might want. The only thing they care about is imposing their will on everyone that they possibly can. And that's why the grand jury movement is now gathering force, but I think that we're shooting ourselves in the foot whenever we use that term common law. We got to stop doing that.
Okay, but just
that's not part.
Yeah, but just to clarify here, there are a number of entities that are going forward now. One I would call a tribunal of conscience, and these are things like the International Common Law Court of Justice, like the Kuala Lumpur War Crimes Tribunal, on which I've served as a judge. And these are entities that fill a gap, and that's a gap where the established courts have failed to prosecute and adjudge a significant major crime under international humanitarian law or under criminal law at the level of genocide, at the level of child trafficking. And that's both the case of the International Common Law Court of Justice and of the Kuala Lumpur War Crimes Tribunal, which had to step in when the International Criminal Court in The Hague was faced with 41 complaints of war crimes in Iraq by UK and US military personnel and failed to take action. And in the case of the International Common Law Court of Justice, when the International Criminal Court or the National Courts of Canada, Ireland, or Italy or the UK failed to take action against the government of Canada, the UK monarch, the Pope, other officials who were engaged in trafficking children, where now we have officially statistics over 300,000 children were trafficked and genocided over this period. We have the statistics now. That's 300,000. That's a large number. So, and the courts were doing nothing because these entities were earning money from this genocide. So there you have these Citizens Tribunal of Conscience were applying international standards of international humanitarian law, the Geneva Conventions, the Conventions Against Genocide, national criminal statutes, etc. And I guess what you're saying is that what you're in favor of is to reestablish and reinforce the Fifth Amendment and to give meaning to the grand juries, because now the grand juries really obey the prosecutors, and the prosecutors in the U.S. have become a medium of oppression. They haven't become for the sovereign citizens. If you're a sovereign citizen, it's more likely that they're going to prosecute you, right?
Well, all the comments that you made about the international common law entities that you referenced, I'm 100% in favor of all of that.
Yeah.
For no qualms at all.
Yeah.
But they're not trying to operate under the Fifth Amendment.
Right.
So we have a problem
exactly.
here because we're trying to get ourselves established under the Fifth Amendment. We're trying to get ourselves recognized by the court system here, and without the recognition of the court system here, we can't go anywhere.
Right.
And so if we use the term common law here, that will prevent us from ever being established.
So
it has nothing to do. It is not in any way a criticism of what you were mentioning.
Yeah. So what you're saying is that you found a way, if you gather individuals who are sovereign citizens, that then...
Well, I don't like that at all.
No?
No, not the sovereign citizen. There's no such thing.
Okay.
That's nonsense.
If you gather individuals if you gather sovereign individuals, that they then can serve sovereign people, then they can serve under the authority of the Fifth Amendment and serve as a Fifth Amendment grand jury. That's what you're saying.
Absolutely.
Okay, we
have to,
we got to the nub of
it.
Okay, so now, how does a person become a sovereign person? You said that you don't have a birth certificate. You mean you really don't have a birth certificate?
Nobody does. Nobody does. You see, it must be.
Oh, I see. I see. Because you are saying that a birth certificate is a logical fallacy, because you could never have acknowledged
There's nothing
that.
about a birth certificate that proves anything.
Yeah,
Yes.
right.
Anybody could use any birth certificate.
Yeah. You're saying that a birth certificate is a logical fallacy because,
It's a nonsense document.
because it there is no way that the infant could have acknowledged it, and therefore you don't have a birth certificate, and so therefore the entire system is operating under a legal fiction. That's exactly what you're saying, correct?
Well, yes. Additionally, it's done intentionally, fraudulently by the government, because the government cannot possibly claim that it is not aware of this, cannot claim that it does not know that all of the birth certificates that are presented cannot be connected to whoever's presenting it.
Yes.
Why don't they ask an applicant to present proof? They can't.
Yeah. Under the law, that's called the legal fiction. In other words, they are operating the entire legal system in this sense under the legal fiction known as a birth certificate.
Well, I want to call it fraud.
It
Because
could be.
the birth certificate, it's because that's what it is. It's fraud. The government is engaging in criminal activity. I want to use those words. I don't want to wishy-washy it around by using words that are more palatable to the criminals. They're committing a crime.
Okay.
Whenever they do this.
Okay. Now, so that what you're saying, I'm just trying to get what does a Fifth Amendment grand jury look like? Walk us through the steps of how a proper sovereign Fifth Amendment grand jury looks like. How is it impaneled, and how does it operate, and what are its outcomes? Just walk us through that.
Well, those who would volunteer to serve on a Fifth Amendment grand jury would of necessity need to present a declaration that they were of the sovereign class, that they had, of the sovereign people, that they had never, ever willingly, knowingly, intentionally ever given up the sovereignty and independence that they were born with, and that any documentation or indication otherwise would only exist because of the fraud committed by the government. So if there was like an advertisement put out in the community saying we need volunteers to populate the Fifth Amendment grand jury, and people in the community who had who could present the proper political standing to be eligible to serve, they could come and put their names on a list, and we need 25 such people. So if there were, say, 100 people who volunteered, then those names could be put in a hat and just pull out the first 25 names, and so those are the 25 people who will serve the grand jury. Then they would be notified, be then assembled at a appropriate time and place, and where they would be sworn in to serve on the grand jury. Then they would put them properly in the position of operating the grand jury for that particular county. So then they would receive any complaints that were brought to them, or if they were became aware individually through their own research or whatever of criminal activity, they could investigate that criminal activity. However, the criminal activity was brought to their attention, and if they determined, or the suspicion of the criminal activity, I should have said, and if they determined that there was actually criminal activity, then they would appoint a petit grand jury to bring that matter to trial, to where the parties, the accused and the defendant and the plaintiff, They would call witnesses, bring it before the grand jury. The grand jury members can ask questions of all of the witnesses. The members can also call their own witnesses. The members could also independently, while they were not assembled in the court, they could go out in the community and do individual investigation of their own and bring that information back and present it to the other members of the petit jury so that they could do the absolute, utmost effort to get all of the information possible in order to come to a determination. And they would also present any evidence that they developed on their own to the parties, to the prosecutor and the defendant, so that they would have a fair opportunity to rebut or present different information in regard to all of it. So the long and the short of that is so that every possible bit of information relative to the issue would be examined by the petit jury, and to enable them to come to a proper and just determination as to whether there was a crime or not.
Okay, now, just questions here. Is the prosecutor also of the sovereign class?
I don't see where there's a necessity of that. But you see, the thing there, when we start talking about sovereign, I need to go into that what you just asked a little bit differently, because there shouldn't be anything in our country other than the sovereign class. What we have here is a subject class that has been caused by the dishonesty of the government. So when that dishonesty is exposed, then we do away with the citizen class, and everyone then becomes of the sovereign class. So then, then the prosecutor would be of the sovereign class.
Now,
but until that is accomplished, we have to go with what we have.
Okay, now, to whom is the determination of the petit grand jury presented for enforcement?
Well, we will still have a sheriff. Sheriff's office would be the enforcement entity.
And okay, so and appeals and all of that, how would they be handled?
I think that the determination of the grand jury would be final. No appeals. So so we're talking about a pure situation, or, okay, well, depending on which way you're going. If you're talking about how it's currently operating, and under the Fifth Amendment, yes, then there would be appeals. But if you're talking about a pure common law situation, then there wouldn't be any appeal, because everything would have already been examined. The parties to the activity, to the prosecution of the accused, the defense part, the defense counsel, the defendant would have had every opportunity to present every piece of information that there was. So there's in that kind of a situation, there would be no statute, because a very high amount of appeals are based on technicalities, because of this statute or that statute wasn't quite conformed with, or something like that. And so we would still have that, but you still have the common law, not the petit jury, but I should have said common law, but you still have the grand jury, who would be superior to any of the courts.
Okay.
That's the purpose of the grand jury.
Now,
so they could appeal it to the grand jury.
Yeah. Now you do realize that there are a number of initiatives in the United States of common law grand juries in various states that are ongoing now.
Well, yeah, they're trying to do that, and I think that that they're making the same mistake as the New York one. They're all involved together, and I think that because they're all entered on the same website that was brought together, created by the Grand Jury of New York, so they're all bound. You know, they're all working together in the same way, making the same mistakes.
And
they should
what,
not be using. What?
Yeah, what in your view are those mistakes? What mistakes are they making, Eric?
Well, the mistake they're making is using the term common law and failing to present declarations of those who are populating the grand jury that they are of the sovereign class, not of the citizen class. The citizen class has unknowingly and unintentionally, but still have given up their sovereign status. And until they individually become aware of that and challenge it, they are still subservient, and they are acting in a subservient manner. They don't challenge the authority of the government. They obey all of the rules as the government tells them to do.
Because
so they're acting. Oh,
go ahead. Sorry, I interrupted you.
They're acting like slaves. They're not acting like sovereigns. They don't even understand what sovereignty is. Most of the population of this country.
Because they have.
They're not taught that anywhere.
Because
they're taught that the government is sovereign.
And that is because they have accepted a legal fiction, a document that's a logical fallacy, the birth certificate, as their reality identity. Is that what you're saying?
That's true, yes.
Okay, now...
That's exactly what has happened.
Yeah. Now, so this was an understanding that, as I see it, you entered into around 1964, so that's over 40 years ago. Is that correct?
64 would be about 50 years ago.
Yeah, about 50 years ago. Now, over the course of the 50 years, how would you assess the level of understanding of that insight in the United States population as of today, say?
Well, I think that it's worse than it was. The prevalence is here. You have two different groups of people that would be referenced there. Those who are in the freedom movement and those who are not. And those who are not have no idea what's going on. They watch TV. They listen to the regular news. They don't have any clue that they have been screwed over, that they've been cheated or robbed. They're proud to be citizens of the United States. They don't have any idea that there's anything bad going on. Now, in the patriot community, it's worse than it was before because of the prevalence of the misinformation, making it so complicated. Now this gold French flag, the upper and lowercase name, the uniform commercial code, the birth certificate scam that when a mother records her baby's name on the birth certificate, she is giving over ownership of her name to the state. I mean, there couldn't be anything more nonsensical than that. Children are not property. Parents do not own their children. Parents cannot give up ownership of their children to the state, but these people put this stuff out. They repeat it currently right now. This is prevalent here in the freedom movement, and you try to get these people to understand that the fallacy of it, the filing rescission documents, rescinding your social security number, rescinding your driver license, all of that kind of stuff is total nonsense. But it's becoming, there are people out there giving classes on it, charging money for paperwork for these documents. It's all nothing but hogwash, because nobody needs to do any of that in order to get out from under the system, as I have proven from my own personal experience and from others who have followed my example, by simply writing a letter to the IRS and saying, IRS, prove I knowingly, willingly, intentionally, voluntarily gave up the personal individual sovereignty I was born with in order to submit myself to the jurisdiction of the United States. When you can present proof that I did that, then you might have some reason to claim that I owed something. But until you do that, stay out of my life and leave me alone. It's as simple as that. The government has no authority over anyone who did not volunteer, and you cannot inadvertently, accidentally volunteer. Well, actually, they did inadvertently volunteer, but my point is that when they become aware of it, then they can extricate themselves from it immediately without filing any kind of documents. Simply say no more. Though the government is criminal, I don't have to give notices to criminals to stop being criminal in order for me to no longer be, molested by the criminals. You people lied to me. I go into court on traffic ticket, and I ask the judge, where did the government or where did the authority come from to accuse me of a crime for driving without a license? And she says, the legislature enacted it. I knew that's what she was going to say. And I said, okay, fine. Where did the legislature get the authority? And she says, well, they were elected. I said, fine. I already knew that answer. And I said, now tell me this. Where did those voters who voted for that legislator get any authority to tell me that I have to have a driver license? Silence. Because the voters didn't have any authority, and if you don't have it, you can't delegate it. Isn't that right, Judge? Tell me this, Judge. This is a woman judge. Tell me this. How many voters would it take to properly and democratically vote your panties off?
What?
And she just sit there and cringe.
You're lucky you didn't get contempt.
Absolutely.
What?
No. No, it was a fair, it's a fair and honest question.
No, but you're lucky you
disrespectful.
you're lucky you didn't get contempt.
No.
Well,
Not
it's
at all. She
it's a
can't hold me
very
in contempt
no,
because she
no, but it's kind of a
cannot be
personal
held in
question.
contempt.
It's kind of a personal
not.
question.
I don't care if it's personal or not. She has no authority over me because the state has no authority over me until the state can prove I volunteered. I was just playing with her because I already had beat the case. There wasn't anything that they could do because the Supreme Court of the United States and the appellate courts of the United States, I had filed with that traffic court a document with about 20 cases from appellate and Supreme Court establishing that when jurisdiction is challenged, it must be proved on the record, not just claimed by the court. And so that's where we were. We were addressing that issue, and the prosecutor was arguing that the legislature had passed this law, and so I was just playing with them, saying, where did the authority come from? And she was telling me that it came through voting. First she said the legislature voted for it. Then she said the legislators were elected by voters, so my question was very relevant. How many voters would it take to properly and democratically vote your panties off? She can't hold me in contempt for that because it was a fair question.
Well,
she was the one who was supporting voting, not me.
No, I understand. I was referring to the risque nature of the question. Now, moving on here. This has been an extraordinary time that we've spent here, and we're coming to the end of the segment. In fact, we've been at it for 90 minutes, but we've really come to a climax, and I think you've been able to bring us to an insight. And it's taken time to really get to that insight, and I want to thank you. As I understand it, you have a discussion group on Yahoo that is, and I'll put this in the group description and also on the video, but it's WHORU, who are you? And we'll put it there so that people can access that and can begin discussions with you. Do you have any thoughts that you'd like to leave our viewing audience with, or ways that people can contact you?
I think that in addition to your mentioning of my Yahoo group, that it might even be more helpful to provide information to those who would be listening to this, to go on to Gene's 2012 blog.
Oh, good.
I know you're familiar with that.
Yeah, we will also do that.
We've got a lot of information up there. We've got a lot of information, current information on this topic up there right now.
Yes, we will. We will also do that. Do you have so both the blog and Gene's rather both your group and Gene's blog, and she has a section there where she's gathered all of your writings together, and you have a very original mind. You've been at this now for 50 years, so you're a singular luminary figure in this area. Do you? Are there any other areas? Any other thoughts that you'd like to leave our viewers with?
I would say this. There's a movie, First Night, name of the movie, starring Richard Gere. The first 5 minutes of that movie is critically important to what we're doing. In that opening segment, Richard Gere plays Lancelot. And it opens with him giving a sword demonstration of sword skills in a town square, where he's engaging in a sword contest with a local, where he knocks the local's sword out of his hand, flies up in the air, and then he catches it. And then he walks around to the crowd, telling everyone, is there anybody else who would like to come forward and challenge me for gold? And he's holding up a bag of gold. Another man steps forward who's about 7 feet tall, and he comes in and challenges Richard Gere. And they battle it out there for a couple of minutes. And Richard Gere then knocks the sword out of this man. Now, this is the important part. After he knocks the sword out of this man's hand, this man walks up to Richard Gere and says, that was really something. Is there something magical about that? And Richard Gere says, no. And he said, well, that was really something. Can you teach me how to do that? And Richard Gere says, well, yeah. And he says, well, what does it take? And Richard Gere says, well, you have to study your opponent for his weak spot. And the man says, I can do that. And Richard Gere says, then you have to watch for the next time that he gets in that weak position. And the man says, I can do that. And then Richard Gere says, you cannot be concerned as to whether you will live or die. And the man lowers his head and turns and walks away. This is our freedom we're talking about. The most important aspect of our life is our freedom. It is more important than our life because without our freedom, we don't have a life. What we must individually have, and I know this from my own personal experience, we must individually have a personal relationship with our Creator. I know I know it. I don't guess. I know it. I am fearless, and I mean that. I'm not afraid because I'm a man. I'm only I only weigh 140 pounds. I don't have physical strength. I do have the strength of my relationship with my Creator. He is here with me all the time. He's here with me right now. I can feel Him. And we must have that. If you listeners do not have that, you need to get it. And you don't have to go to church. I don't go to church. You don't need to read the Bible. I do that sometimes because there's a lot of good stuff in that book. But my primary spiritual contact is directly with my Creator, one-on-one. And you can have that as well as I do. And that will give you the strength to stand up no matter what the opposition is. Without that, we can't go anywhere.
Thank you for a very profound teaching and a very profound experience, Eric Williams. Thank you for being with us, and we look forward to having you back again as events develop. Thank you.
I look forward to that myself. Thank you very much, Alfred.
Certainly. Goodbye now.
Goodbye now.